or a notice of appeal was appropriately filed, all within the appropriate time frames. Today, Your Honors, there's two issues that we've raised before the court in our appellate brief. The first issue is one of the admissibility of relevant evidence at the trial. Specifically, the trial court denied admission of a receipt procured by my client to show that he had purchased the item from a third party from a friend, but who that friend had gotten it from a reputable pull-apart dealership. Your Honors, looking at that issue, the standard of review with regards to the admission of evidence is an abuse of discretion standard, whether or not the trial court has substantially complied with the procedures mandated by the rules of evidence. Under Rule 401 and 402, generally speaking, any evidence that is relevant and helpful to determination of facts in the case is admissible. Under Rule 901, the admissibility of evidence has to be authenticated to a certain degree, and in this case, the judge ruled that the evidence was not able to be properly authenticated and therefore denied our request to admit this piece of evidence. Specifically, during Mr. Graham's testimony, he sought to introduce evidence whereby he had received a receipt stating that he had purchased that a hood had been purchased from Pull-Apart. Mr. Graham stated that he had gotten the receipt from a friend, Mr. Sutton. If Your Honors look at the record, you will see that we had testimony with regards to Mr. Sutton's lack of availability. We had diligently sought Mr. Sutton during the time frame before the trial, but were unable to locate him, and as a result, he could not testify, which is why we were relying on Mr. Graham's testimony, as well as the testimony of Ms. Lamb, to bolster the fact that he had received this receipt from Mr. Sutton. We understand that that means that the initial provenance of the receipt was not provable by Mr. Graham, as Mr. Graham had not himself obtained the receipt from Pull-Apart, instead from Mr. Sutton. However, part of the issue is that Mr. Graham was attempting to show that he had reason to believe that these parts were legitimate because he had purchased them from Mr. Sutton and received a receipt from Mr. Sutton. To that end, we believe that Mr. Graham displayed an appropriate level of knowledge as to the receipt and to where he had received it to be able to testify to its provenance to him and satisfy 901 for the admission of this evidence. The trial court disagreed and held that evidence out as a result. Holding out of that evidence had multiple effects. The first issue that it has is that it effectively prevented us from bolstering Mr. Graham's testimony with the evidence. It prevented us from showing why Mr. Graham had a good faith belief that these were legitimate parts, or at least the legitimate hood, that had been sold to him by a third party. Having that excluded also, by its very nature, undermined his credibility because the jury was aware that we had attempted to introduce this evidence and it was being held out and therefore did not satisfy the judge in some way, and we would contend that that, by its nature, undermines Mr. Graham's credibility in front of the jury. We would also point out that in addition to Mr. Graham testifying as to the receipt, Ms. Lamb also testified as to the receipt, stating that she witnessed Mr. Graham purchase the hood and get a receipt from Mr. Sutton to the transcript of page 167. We believe that those together should have been enough to satisfy the court with regards to the admission of this piece of evidence and its inclusion into the records. If there are no questions on that particular point, I'd like to move forward to the sufficiency of the evidence argument. With regards to that argument, we recognize that the standard of review on a sufficiency of the evidence is very, very high. Once the jury finds the defendant guilty, his presumption of innocence is removed and replaced with a presumption of guilt. The state is entitled to all reasonable inferences and legitimate inferences in their effect. But our argument is that while that is a high burden in this particular case, there were unreasonable leaps and inferences that could not overcome that burden. Specifically, the state points in their reply brief that there's no difference between larceny and receiving or concealing stolen property, as stated in State v. James. But while there's no difference in terms of the actual statute of the law, there is a significant difference in terms of what factual evidence supplies both of those issues. In this particular case, the state's witnesses all admit on the record that they have no evidence and no knowledge that Mr. Graham stole these items himself. Ms. Mays stated that she saw a video camera capturing the theft. She was unable to identify any characteristics of the people that took her hood, the hood of the truck. Mr. Mays, her son, testified that the video of the theft was so grainy he couldn't see anything. He also admitted on the stand that it was an assumption that Mr. Graham had participated in the theft of the hood. Finally, Officer Ott stated that he had no information showing that Mr. Graham had actually removed the stolen items from the truck. Again, this was all based on finding the items at Mr. Graham's home 2 weeks after the theft of the items. While not conceding whether the hood belonged to Ms. Mays or not at trial, this defense provided proof in the testimony of Mr. Graham and our other witness that they had legally purchased the hood from a friend. No evidence presented directly showed Mr. Graham was aware of the nature of the hood or should have been aware that it was stolen. In fact, they maintained that Mr. Graham had maintained his assertion that he had purchased this hood throughout the entirety. There is a slight discrepancy in terms of the initial explanation that it was purchased from Pull-Apart versus the later explanation that it was purchased from a friend who got it from Pull-Aparts. We would contend that that's very directly the fact of someone asking where the part came from and not wanting to go into your whole life story upon meeting somebody for the first time. It's very natural to not go into that full explanation. It's not a discrepancy or a lie. It's simply something that gets cleaned up as we go along. There's no discrepancy between those statements. Given those issues and the uncontroverted testimony, the hood was the only item that was identified for sure. While there was statements regarding other pieces that the victims in this case believed may have been from their truck, they could not positively identify them due to the nature of those pieces. And as such, only the hood was at issue in terms of clearly an item that had been previously owned by the Mays in this case. We would contend that those leaps, the leap in logic that he must have been aware of the nature of the hood simply cannot meet the burden in this case, and that the jury erroneously made leaps on behalf of the prosecution.
Okay, thank you.
Thank you, Your Honor.
May it please the court, Christian Clace on behalf of the state. I'll start with the receipt issue. The defendant has not proven that he is entitled to relief based off of the trial court's exclusion of the receipt from evidence. As an initial matter, I will flag the relevant receipt is not in the record. All we have to go off of is the jury out hearing, where there is a brief description of the receipt that the defendant attempted to produce into the evidence. Even so, the defendant has not proven that the trial court abused its discretion. His argument effectively seems to be that because the receipt was extremely relevant, it should have come in. This is the argument that was made in the brief, and this does not weigh on the fact that the trial court found that the receipt was not properly authenticated. And I would like to clarify one aspect of what happened at trial. The state did not object when the defendant testified that this was a document that he received from his friend, Mr. Sutton. The state did object when the defendant began reading the receipt for the purpose of showing that an actual hood was purchased from Pull-Apart. So the state is not objecting on authentication grounds that the defendant couldn't authenticate that this document was given to him. The objection, and what the trial court considered at the jury out hearing, is whether this witness had the knowledge to testify that this was an actual receipt. And that's where the trial court kept the receipt out on Rule 901 grounds, and it did not abuse its discretion doing so. Even so, if this court were to find any error with the exclusion of the evidence, that error would be harmless. The jury heard proof through multiple witnesses that the defendant possessed multiple parts from the victim's vehicle. The receipt at issue only referenced a hood, so the defendant is not correct that the receipt would in any way be exculpatory because it provides him no answer at all for these other parts that the state showed that he possessed at trial. Additionally, the jury heard multiple times that he believed he purchased the parts legally. They heard this from the defendant's girlfriend, and they heard it from the defendant himself. They simply didn't accredit the testimony. So if this court were to find that the receipt should have come in, any error is clearly harmless in this particular case. Turning to the sufficiency issue, the trial proof showed that the defendant possessed a hood identical to one stolen from the defendant's vehicle. It had the same scratches, the same dents, the same color scheme. There really is no dispute at all that the defendant possessed the hood from the victim's vehicle. And viewing the proof in the light most favorable to the state and accrediting the state's witnesses, the defendant did possess other parts from the victims as well. Brad Mays, do you have a question, Judge Witt? No. The state presented proof that the defendant possessed a truck grill as well from the victims, and the testimony at trial was that this grill had the same scratches that was on their truck grill. So the defendant had the hood, he had the truck grill, and then there was also testimony that the defendant possessed the same type of upper radiator support that was stolen from the victim's vehicle. And even after the defendant was told that these particular parts were stolen, he proceeded to sell the truck anyway. So based on this proof, the state would submit that the evidence is sufficient to sustain the conviction for theft of property. And unless this court has any further questions, I would ask that you affirm the judgment of the trial court. Thank you.
So just to make sure, the receipt is not even in the record for our review.
No, Your Honor, as the receipt was not allowed in by the trial court, it did not appear on the record.
But the trial court examined the receipt in making its determination that it would not be admitted.
Yes, Your Honor.
So we don't know what the trial court looked at.
I believe that the trial court's findings with regards to the receipt are very clear. It's a full explanation of what the receipt is and what the trial looked at in terms of making their decision when they examined it. I do believe that the record is fairly clear on this issue.
Okay.
Just briefly, Your Honor, with regards to the other parts and viewing things in the light most favorable to the state, we concede that that is a high burden, but we would point out that the trial testimony is that they believed that it was similar to the item stolen from the truck, but that there were no identifying characteristics or any other markings on most of the pieces, including that upper receiver piece that's been mentioned, that could positively identify them as items that had been taken from the truck. So given that, we don't believe that the inference should be drawn as far as it was. That's all. Thank you, Your Honors.
All right, thank you. Thank you for your argument today. Does that conclude the court's docket this term?
Yes, Your Honor.
Court will be adjourned until the opening of the June term.